Hi, this is Senator Malcolm Roberts with The Malcolm Roberts Show. Our aims, I'll remind you, are to restore our country and our planet for humans to flourish. We've had some marvellous feedback on our shows with Tony Heller, Peter Ridd and Dr. Philip Altman last week. So we're very, very pleased now to bring you something else, another topic. And that is to deal with an issue that has really plagued coal miners in Queensland, my home state, and New South Wales in the Hunter Valley, where I used to work in the past. It's a really serious issue that is troubling thousands, tens of thousands of miners, and we'll really show you something that'll open your eyes up today. But firstly, I want to thank you for listening, having me as your guest in your car, your kitchen, shed, lounge, barbecue, or wherever you are right now, sitting, standing, driving, walking, running, laying down, exercising, who knows. The themes of my show, there are two themes. Freedom, specifically freedom replacing control. That's the eternal human struggle. And secondly, responsibility, specifically personal responsibility and integrity. And the two guests I have this morning, I'm getting goosebumps about to talk about this. The two guests I have today, Sam and Simon, show huge responsibility. They took personal responsibility for tens of thousands of miners in Queensland and New South Wales. We have been pursuing this issue with them, for them, and for 30,000 coal miners in Australia since 2019, mid-2019, heading on for 4 years. And it'll sicken you with some of the things that we'll be discussing. But we'll also be providing solutions. History repeatedly proves that both freedom and responsibility are absolutely essential for human progress and for people's livelihoods. So now I'd like to welcome Simon, I've forgotten your name, Simon Turner. Crazy, after we've been dealing for so long together. And also Sam Stevens. Simon, before we go into your background, something you appreciate today?
I appreciate living in Australia and being able to do and speak out freely and to try and hold the powers that be to account when they fail everybody. Everybody deserves a fair go.
Yeah, and I want to restore Australia. That's the problem. We've lost some of those basic rights in the last couple of years, Simon, under COVID restrictions, but we need to get them back. But fundamentally, we're a very good country. Sam, something you appreciate?
Freedom of speech, Malcolm. To be able to speak your mind, backed up with facts. That's something that's been ignored for some years until we've had your help. We're starting to establish the facts behind what's plagued the industry. That's very important, right? And freedom of political association as well.
You know, and I'll set the scene here because my grandfather was in Wales. He was born and died in Wales. He worked as a coal miner underground. He died from black lung disease. And workers didn't have much protection in the 19th century in Wales, in the valleys of Wales where the coal miners worked. And unions were formed, and they did a damn good job of protecting basic rights like workers' safety, workers' pay rates, workers' working conditions, workers' retirement, and basic fundamentals of health and security. And unions became very strong. And as a miner at the coalface, mostly underground, I appreciated unions. I thought they went a bit far at times, but they were helpful in my growing up and working in Hunter Valley and Queensland, and also around Lithgow in the Western District. But we've seen workers today, as you'll see with Simon, who have completely lost all protection, due to the complexity of the industrial relations system and the corruption, and Simon and Sam will go into that. So I'd like Simon to start off, because there's nothing more important than workers' protection, lives at stake. Simon, tell us what happened to you, mate.
I was lucky enough to get work in the coal industry. I was very safety conscious. I was well aware of things that were going on within the mining industry. I was seriously injured through no fault of my own. And when that happened, I started to find out literally if you work for a labour hire company, how you do not receive any protection, any of the entitlements that's been afforded to coal miners in the past and to this day, and what generations before us fought for within the union and what they uphold and stand for. They have been totally removed. If you work for a labour hire company, you have nothing. There is no protection whatsoever. After we've highlighted this in the past, there may be a little bit now, but it is nowhere near what the laws say it should be, or what they are, because they simply don't apply. They've obfuscated around these laws.
Can I just build on that, please, Simon? And jump in, Sam, if you want. I know we need to get to the core of the issue that you have highlighted as a result of chasing what happened to you. But basically, casual employees are under immediate threat of being dismissed at some mines if they dare raise a safety issue. That's number one. So they've lost that ability to speak up. And that's despite union check inspectors and despite district check inspectors and despite on-site coal mine check inspectors, correct?
Yep. And I was a first-hand witness to that, working in the Hunter Valley. And these two matters that we'll talk about later on in the Fair Work Commission and the court relate directly to that person and safety issues. And she was told, we don't want you here. She worked there a month.
And then the second thing is the unions fought very, very hard and successfully over many years in Britain and in Australia to have workers' compensation. If a mine worker was injured, he or she was compensated. You got no workers' compensation.
Well, I did. I got it under the statutory New South Wales system. But legally,
you got no coal mines and no coal mines insurance workers' compensation.
No, I got workers' compensation as I was employed as an office worker and earned $28,000 a year. That's what my compensation was for in the New South Wales workers' comp system. No,
so they
no
lied.
coal mining entitlements. Yep.
So they lied. That was fraud to get their workers' compensation premiums down. You ended up with no coal mines insurance workers' compensation. You then eventually got onto the state government system. So the state government, so the taxpayers of New South Wales are paying for your workers' compensation that your employer, Chandler McLeod, should have paid for.
Yep, exactly. And not only me, many others.
They're bludging off the taxpayers.
Yep. They are not paying anything that legally must be afforded to a person injured in or about a coal mine. The reason being, they hide it under our occupation. They put a false occupation on the certificate of currency for the workers' comp policy and declared that I earned $28,000 a year. Now, they then, not only that, they sacked me within 2 weeks of being injured. No one at that point in time knew what damage I had done to my spine and everything. What they did then was they didn't tell me that they'd sacked me. I found out later via Coal Mining LSL Corporation, but I was being paid directly from the New South Wales government, ABN, the New South Wales Work Cover Authority. Now, they haven't been legally been able to insure coal miners since 2005. They applied a PRWE. Yeah, I'll just go on. They applied a PRWE, which is a pre-injury average weekly earnings calculation. Now, coal miners are exempt from that because you get your 78 weeks accident pay, full pay. Now, what they did was after week 25 or 26 it was, they dropped my pay to 80% of the full pay. Now, I was getting paid $400 a week. Now, they couldn't, the calculation that they were showing was false because they were paying me 80% of $28,000 a year.
What were you earning when you're at work?
Well, this is another issue that we'll get to later on in here. They tried to falsely claim that we were earning $92,000 per year. but that's totally false and misleading. One, because what they've been doing, we've now discovered through taxation records and documents, each year and this is where the labour hire companies falsely, supposedly lose contracts. What happens is one of the labour hire companies delays sending through the PAYG summaries. So what it does, you've actually got two companies paying you that wage in the financial year, but the last company, when it's investigated for wage theft and what they're paying, it looks like they've paid a larger amount when they've actually, I'll tell you what I was paid, $66,000 gross for working 12-hour shifts in a coal mine.
So the point is, you were on 66,000. Some of the mates doing the same job as you, the same equipment, operating the same way, the same responsibilities, were getting a hell of a lot more. You were about 40% underpaid at least, from what we could work out.
Roughly around 148,000.
Right. So you were massively underpaid, doing the same job at a union work site, and you weren't getting the workers' compensation to which you should have been entitled. So they were diddling you there, and it's based on fraud because they registered you for the sake of workers' compensation as an admin worker with a much lower rate of pay and a much lower risk threshold.
Yep, in the New South Wales system, the coal industry in New South Wales has a legislated monopoly insurer for workers' comp, which is Coal Mines Insurance, which is owned 50%. By the CFMEU and the other 50% the Minerals Council. So you've got the owner of the insurance company is the union, and the mines owners as a group, the ones who, this is where the cover-up of the numbers of workplace injuries in coal mining has occurred as well, because all those records are held with Coal Mines Insurance.
Okay, now do they own it, or are they just directors on the board?
No, they own it. 50-50.
They own it, thank you. Okay, so we've got the CFMEU being 50-50 owners, directors of the Coal Mines Insurance scheme protecting, and yet you didn't get covered. I just want to move on quickly because time's marching and we've got a lot to cover here. I made a submission to the Grosvenor inquiry into the serious accident that almost killed 5 people. Because the same thing's happening in Queensland. People are afraid to speak up about accidents, about near misses, about threats to safety because they might get sacked. So what we've got is also in New South Wales, you showed us documents, Sam. I mean, Sam has done phenomenal research, and so has Simon. Phenomenal research. We've been witness to them for hours. Now, we saw reports from New South Wales, I think it was the Mines Department, Simon and Sam, that showed at a time, and we were sitting in a room with 8 people who'd been injured over the various years, and each of their injuries on each of the years showed no accidents, no injuries for casual employees in New South Wales at any time that year. The report is complete bullshit.
That's correct. There was no LTIs, lost time injuries, reported, and everybody sitting in that room were all injured within that time frame. Plus, there was a lot more than that. It just happened to be a group of people in that room at that time.
That's right. And the category was for employees of labour hire firms. It didn't specify whether they were casual or not, but 85, 90% of those employees will be casual. It's the business model.
Yep. So here's the government statistics showing no accidents, no injuries, yet there were many. No. We were sitting in a room with 8 severely injured people. Simon's been totally and permanently disabled. So let's move on for safety. Safety is always the number one thing for me. It always has been all through my work in the mining industry. Let's move on to pay. That was the second issue that got me. And by the way, to people listening in, I must compliment Stuart Bonds. He contacted our office before I got into the Senate and said, mate, you've been working in the Hunter Valley in the past. Can you help us with an issue? And I said, depends if I get into the Senate or not. So once we got into the Senate, one of the first things we did was telephone Stuart and met Simon. Simon came down to Canberra at his own cost. We then moved up with 2 of our barristers and Stuart to listen to 8 miners, in male and female, in Williamtown at a hotel there, Simon, from memory.
Yeah.
And we listened to what was going on. And I always remember, I've got a barrister who works in my office, and he's a very careful, very considered person, gives phenomenal advice. He just blurted out in the middle of listening to you guys, "That's fraud." And I was stunned because Hugh doesn't do that. So let's talk about pay rates now, Simon. That's the second major issue. Safety first, pay rates second.
Yep. Well, everybody that works in Australia that's a national systems employee, which coal miners are, there's a set of lawful minimum entitlements which you must be paid. They cannot be removed or displaced. Now, that is the award for the black coal mining industry. It's called the Black Coal Mining Industry Award 2010, and prior to that, it was the Production and Engineering Award. Now, at no point in time have both of these allowed casual employment ever in production and engineering roles. In an office, you can be. Out in the pit, you cannot be a casual employee. Simply because...
So I want to emphasise that point, Simon. To comply with the Black Coal Mining Industry Award, only permanent employees can be in production roles.
Yeah, full-time or part-time. Now, it's impossible to be part-time because we work 12-hour shifts. Now, the 12-hour shifts, the Black Coal Award full-time threshold is 35 hours per week. We're way above that. Now, under the NES...
So your rostered time, your rostered time is more than 35 hours a week on average.
Yeah, correct. Yep.
Correct,
now,
right.
Under the NES, 38 hours, which is what covers everybody else outside of the coal industry. If you work 38 hours, you're a full-time employee. We're above that threshold as well. Now, no matter what you work, you cannot be a casual employee. It's as simple as that. Now, going to the pay rates, what they do when they've been getting these enterprise agreements submitted for approval, they don't, how could I say this? They don't put through the roster that's being worked, the actual roster, which is unbelievable how they say, oh, we don't know what it is, which is total BS because they simply have to tender for the work at that coal mine. They've got to know what the roster is and what they're paying everybody and work out their profit margin. So they know this the whole time. Now, the award in 2014 on my worked roster, with all the entitlements applied, paid $144,000. That's under the Black Coal Award. Now, what the union and the companies have been misrepresenting, that the Black Coal Award pays far less than that. At no point have they ever shown what the Black Coal Award paid with a work roster next to it, using those calculations. No one has done that ever. I'm the first that's done that, and people, choose to ignore it. They just simply, if something's ignored, then it's not relevant and it's not forefront for everyone to look at. Now, this is the basic legal minimum that you can be paid, is a Black Coal Award, and that's $144,000 a year in 2014. Now, I guarantee you that none of these enterprise agreements that the CFMEU negotiated and endorsed pay anywhere near that. We know they don't, because Sam's done an in-depth study into actually how many enterprise agreements the union endorsed and negotiated that have removed all of these entitlements that cannot be removed. Now, Malcolm, you got the Fair Work Ombudsman and the Fair Work Commission to admit that in Senate estimates on Hansard and video recorded. Now, they said, you said to them, can a contract or an enterprise agreement remove the award and NES entitlements? And what was their answer? No.
No, it cannot.
Yep. Now, all of these EAs that the CFMEU's done have done that.
Yep. So let's establish the first point. First point was safety. Second point is pay rates. 40% below doing the same job as a permanent employee right next to you. Because you're on labour hire, you got 40% less.
Yep.
Correct. Okay. the first thing is, let's go right back to basics when you first started with Chandler McLeod. You weren't on an EA, were you? You were on the award. Chandler McLeod was employing you illegally because the award does not allow the employment of labour hire people, of casual people on production roles. You were employed illegally, correct?
Yep, that's correct. And I'll tell
Absolutely.
you how
Both of us.
that occurred. We were at the mine site with Tessa, which was previously a CFMEU-owned labour hire company. Now, we were called in, we were told that Tessa's lost a contract. There's all the paperwork there for Chandler McLeod. And by the way, you've got to take a $6.50 an hour pay cut. Sign the paperwork and you can go back out there and work. Now, what we found out is that, and we've got this in writing under a FOI that I did to the Fair Work Commission. Commissioner Stanton was the matter. The union wrote to everybody in a newsletter advising everyone about this, and I thought, hang on, there's a matter here listed in that. So we go into it, and sure enough, in the email exchange between the Chandler McLeod senior manager and one of the heads of the union that were looking after this, Shane Thompson, he said, can you confirm how they are employed, what instrument they are employed under? She came back with, they are employed casually under the Black Coal Award. Now, the problem is there is no pay rate for a casual. That classification doesn't exist in the award, and they were paying us as that. Yet we were still working full-time 12-hour shifts. Now, that matter just simply disappeared. It got hidden in the Fair Work Commission. They said it didn't exist.
And that's one of the things you want to draw attention to, isn't it, Simon? We'll put them together later on in this show. The number of things that have been hidden.
Yes.
By the people who are supposed to be protecting you.
Yeah.
So by
the CFMEU are
and
charged with that
Valley?
responsibility within the coal industry for protecting workers' rights,
Correct.
whether they're union members or not. And I know now they're wanting to charge non-union members. I should say that my family history goes back on from Welsh descent, and both of my great-grandparents and family all worked in the coal industry. My great-grandfather was in the Rothbury riot. He was locked up and put in jail. Uncle Frank McCarran was also one of the highest office holders within 2 districts and areas of the CFMEU.
I've met Frank some years ago.
Yeah.
Personally met him.
Yeah.
He had snowy hair.
Yeah, very silver hair. Yeah. Now, if they knew what was happening and what I've been through, I couldn't imagine what they'd say. It's not what they fought for, and basically, Pop McCarran got locked up and put in jail.
Yeah, and Rothbury riot, for those who don't know, Rothbury is a tiny town in the Hunter Valley. There was a riot there in which I think a miner died, and the police were sent in to bust them up. And that was very, very important. It's in the folklore of the union, something that was very proud of.
For all of these terms and conditions we're talking about now, yeah.
Yep. So let's come back to the CFMEU on that score, but let's continue with identifying the problems. So the pay rates are remarkably less. You're underpaid. You're illegally employed to start with. Your enterprise agreement was not properly passed. So we'll come back to those issues. The third one was coal long service leave. When we first raised these issues, one of them was coal long service leave. Now, every mine worker is entitled to have his employer pay a levy into a fund for coal long service leave. So what that means is that after you've been in the coal industry for 8 years, you then get the entitlement to 13 weeks leave, isn't it? Fully paid,
yeah, that's
Simon?
Correct. Yeah.
That's what I thought. So we had this. Now, we found out that the coal long service leave mob were putting away differing amounts for casuals, different rates for casuals compared with permanents. And then they're paying them out at different rates as well. That's if the casuals hung around long enough to get to the 8 years. So that raises serious questions too, doesn't it?
That's right, Malcolm. Can you name another industry where a casual, in brackets, can obtain long service leave?
I see what you mean. The definition
sense,
itself is stupid. Yeah, and people need to understand that when Simon, and you've worked as a casual worker too, you have your rosters 2 years in advance, correct? And it's exactly the same as the full-time permanent employees. So how can you be casual?
No,
that's right. It's impossible.
And the other point I've got to make too about being a casual, look, I was a union member for many years. Even after Simon had told me I couldn't be casual, and he'll agree, I pushed back pretty hard because I'm very close to being at my fifth year, or fifth full complete year of being a casual. So I was pretty much a doubting Thomas. I still kept my union membership on there for probably 6 months or so after Simon first told me. I couldn't believe it. And see, the other point I've got, when it comes to voting in enterprise agreement, if you haven't had the minimum rights and protections of the award communicated with you, how can anyone cast a valid vote in an EA? You're uninformed. It's an abject failure. I'm not a union basher. I just don't like what's happened to us, and the fact that the union has to hide to charge people casual membership. They're charging them for something that only exists through their will. They've never blown the whistle, and that's a core issue. I am definitely not anti-union. We need unions, just don't need to be treated like the treatment we've been meted out.
Well,
I'm just anti-corruption.
Yes, same here.
Correct. Me too.
I'm very strongly pro-union, providing people have the choice as to whether or not to join, providing unions do their job. But I'm very pro-union. And there are many, many good unions in this country. Sadly, some of the large unions have become corrupt because of two things. First of all, in my opinion, two things. Complexity of the industrial relations system and a complete lack of accountability. So when you get that free rein and no accountability, it brings to corruption. Give us some of the examples that you've seen in corruption. So we've got 4 issues: safety, workers' comp, pay rates, coal long service leave. Simon, in the coal industry, when I was a miner in the 70s and 80s, in the coal industry when I was a mine manager and a general manager, you just did not fool with safety, pay rates, workers' comp or coal long service leave. You just did not touch it because the union would be down on you like a ton of bricks.
Exactly.
It's wrong right. Anyway. It's morally incorrect.
Yeah.
So
and
what happened? Why did the union suddenly sell it?
They were the owners of one of the original labour hire companies within the coal industry. It started here in the Hunter Valley, and they moved another one, set up another one up in Queensland. Now, I have sort of a direct connection to this. The company originally, the company name was like an ABN number. It was then called UMS. I had a friend who was
Excuse me, that was United Mine Services, because I was a manager in Hunter Valley and dealt with the United Mine Services.
Mining Maintenance Services, it is.
Thank you. Yep.
Now, I had a friend who was employed by them. He was killed underground at the Gretley mine disaster, sadly. Now, once I did a bit of digging and looked into everything, that company UMS, they were never prosecuted for the deaths of the 4 people that were working for them. They were granted leave. They were not prosecuted by the current New South Wales Attorney General at the time, Jeff Shaw.
There was a hell of a stink about Gretley. The mine manager was chased and prosecuted.
Yeah,
there's a big stink going on there. But you mean to tell me the employer was not?
No, they were not prosecuted. They were granted leave.
I think it was 3 of the 4, Simon.
Yeah, 3 of the 4. 3 were. There was 4. Yeah. Now, they then changed their name. There was a couple of other name changes within that sort of quick time frame. There was JVUN set up. Now, in between this time, they're negotiating and doing enterprise agreements for these companies and stipulating, or a mandate, if you like, that mines must use this company to employ casuals within the mining industry.
Trade agreements, one example.
Yeah. Yeah, and that was in a submission to Parliament where they used that example. Now, that company, you think about it, you've got the CFMEU owning the labour hire company, doing enterprise agreements, adding the classification, it's illegal. They're also keeping the records that company is submitting and the payments to the superannuation company, right? But not only that, that superannuation company, as we find out, has also been doing and keeping all the records for the Coal Mining Industry Long Service Leave Funding Corporation. Plus, they hold all the records for coal mines insurance because they own the whole lot. Right, so there's an enclosed loop of record keeping that can never get out and has never been reported as to being wrong. Now, at the last set of estimates, you've exposed that, and there's no way she wanted to say who she was employed by and what was going on from 1992 all the way up until 2017. Auscoal / Mine Super, Mine Wealth and Wellbeing, it's had quite a few name changes, was the contracted administrator that carried out the day-to-day function of the Coal Mining Industry Long Service Leave Funding Corporation. So the union are directly involved in all of this and all the record keeping. Now, at that time, I was deemed TPD by
Totally permanently disabled.
Not to work in a... Now, you've got the administrator of Coal LSL Corp deeming me TPD, but they're not telling Coal LSL. I said, it's got nothing to do with us. They're administering the scheme. I was paid that and deemed that at that time when all this was happening. They refuse to acknowledge that I've been deemed TPD. They say it's up to the employer to report it. Now, I took that matter to the Fair Work Commission. They told Commissioner Hamburger that, we'll go away and change it. Because he said, hey, what's going on here? The next day they rang up and said they're not going to change it. They told the lawyers that I had at that point in time they weren't going to change it. I then filed the matter in federal court after a great deal of push for the lawyers at that time, a Darrow law firm, who were also the class action lawyers, to have the matter heard from my TPD in the federal court. Now, what they did was that never got aired. They moved it into the class action. A matter that only concerned me was moved into the class action, and the class action subsequently were never heard. So the matter never got out. Wow. It was stifled. Right? To this day, it still hasn't been dealt with. None of the information has been put forward. If a judge or anyone else sees exactly what I have here, they will just go, what is going on? I can prove everything.
And
go on,
now
Sam.
Perhaps we can link over to the class action, Simon. Simon's question to the Fair Work Ombudsman recently, whether the Risotto decision was hampering any of their legal matters, and they didn't want to answer straight, so you didn't get a straight answer, but the straight answer is no, it doesn't. And that's one of the key issues that allegedly brought the class actions, which Simon was lead claimant for. That's what brought it to an end. So the point is that Simon has made, and I totally agree with him, if Risotto applies, no casual worker could ever claim for any back pay. And yet we see just recently West Farmers have been nailed with an enforceable undertaking. Amongst the claim is underpayment of casual workers. And the second
in any industry, that is, Sam, not
that's
just the
right,
rail industry,
yes.
Any industry. So what's the need for the Fair Work Commission or Ombudsman if no one can bring a claim because of this so-called contractual High Court matter that was handed down, which was, a contract can't remove legal minimum entitlements. It's a fallacy that's being portrayed out there by all involved.
And that's correct. And the advice...
Keep going, Sam. Keep going.
Sorry, the advice from the Fair Work Ombudsman has never changed. Pre-Risotto, it was formatted in one colour scheme. Then about 3 months after Risotto decision was handed down, they completely reformatted the page, I've got screenshots of both. It physically looks very different now, but a common law contract still cannot remove statutory entitlements. And that advice has been consistent all the way through pre and post Rosato. So the effect of Rosato is buried.
Yeah. The other thing is they tried to portray and use, they said that we're employed by a different company. They said we're employed by Ready Workforce, which is totally untrue. Where we go to the court case, the Albertelli court case, the Union v Hunter Valley Energy Coal, where they dug deeply and examined all the documents and said the employer is Chandler McLeod. Now, the reason why they've...
Hang on, let's unpack that just for a minute. Hunter Valley whatever it was, coal is energy coal is BHP, right?
Mount Arthur, yep.
Okay, and BHP is the mine owner and the mine operator. They're the mining company. But they contracted with Chandler McLeod to provide labour hire people, casuals. And Chandler McLeod was their employer. End of story, correct?
Correct. We have all the documents that are legally held demonstrate that irrefutably.
What it also shows in those documents with the purchase orders and that BHP were actually paying Chandler McLeod the Black Coal Award for us, for a full-time employee. Chandler McLeod was simply paying us much, much less. It shows that. Our hours, my name's on there, there's many people on there, on the purchase orders and everything that's been done. It shows that they were skimming. They just simply weren't paying us our lawful entitlements. Now,
so that had to be deliberate.
Well, it's not a typo.
when Simon's ready, we can introduce as to why this great deception has been introduced, and we'll link back to the Commonwealth Government Contracts perhaps in a minute, Simon.
Let me just give you the foundation, because I just want to clarify for people who are not familiar with the coal industry or even not familiar with Queensland and New South Wales. When I was a mine manager in the Hunter Valley, we dealt with United Mine Maintenance Services, all right? They were well-intentioned. The CFMEU set them up because there was a massive retrenchments in the Hunter Valley, and it was a very good cause because we were called up as mine managers and told, if you have a temporary position or if you want to do a longwall move or something like that, come to us because we've got the people. I later found out, and that was good, I later found out from the larger division of the construction side of the CFMEU that they were opposed to that in the first place because it made a conflict of interest in the CFMEU and the Hunter Valley, because the CFMEU was an employer, but it was a union. So that set up a conflict. And that's important for people to understand, because Simon, I'm going to ask him a question in a minute about some of this corruption going on. So then, Simon, my understanding is that United Mining and Maintenance Services, part of it was sold, and the CFMEU became part owner, and the private owners took over, and then it became entirely private, but with links to the CFMEU and some delegates potentially, from what I understand. And then it became flogged off as something else. But the point is that the CFMEU used to say one thing to people publicly, and that was that casual work is terrible. You should not have casuals. But they were an employer of casual people, and they were facilitating enterprise agreements for casuals. So at the same time as they were denigrating you guys, bad-mouthing you guys, they were saying to other people, here's an enterprise agreement that we will sign off as the CFMEU, and you can employ casuals. How did they do that? Was it, did they set up shelf companies? Did someone else set up a shelf company? Then once they got the CFMEU agreement, it rose in value? Well, how did that happen?
Well, they were profiteering from illegal employment and basically wage theft with the company that they owned. Now, if you're not employed under the award, you can only be employed under an enterprise agreement. Just so happened that the company that needed the enterprise agreement was owned by the CFMEU, and they're the ones that negotiate and endorse the enterprise agreements. So it was all... They created the loophole that they supposedly talk about now that exists.
And then
it's
you
not
come
a
back to
loophole,
Sam's
it's
point.
simply ignoring laws, yeah.
you come back to Sam's point, before you, as a union member, or even as a non-union minor, casual or permanent, if you're given a vote on an enterprise agreement, you should be told what is in that and what are the basic conditions that you're contravening or should be aligned with.
On the Fair Work Ombudsman's website and Fair Work, they tell you that, this is what an employer must do for an enterprise agreement. And one of the things, they've got to tell you what the Black Coal Award is worth next to the enterprise agreement that they're wanting you to vote for. Now, at no point have I seen anywhere, and I don't think Sam has, and he's examined hundreds of these enterprise agreements, do they ever show the weekly wage of the Black Coal Award on the worked roster? It's never been shown. So no one's ever been able to make a clear decision. Now, you imagine, you put yourself under the award, I can earn, so for example, 2014, I can earn $144,000, get 6 weeks paid annual leave, 20% leave loading, paid sick leave, carers leave, or I can vote for this EA and be paid $66,000 gross and be sacked via a text message. What do you reckon people would vote?
After being TPD'd with no mining workers' compensation. So
the Chandler Enterprise Agreement, and in the application for that, and this is signed by the union, negotiated, they say that accident pay was removed from the Black Coal Award in 2014, which is totally false. They'd actually, not long before that, fought at the Fair Work Commission it to stay in the award itself at 78 weeks. Now, they say that this was removed from the award in the application for the EA. But not only that,
That's right.
We go back to the Fair Work Commission matter where they say we're employed under the Black Coal Award and you can't be a casual. Well, guess what? They say we're casuals. In the vote demographic breakdown in that EA application, they say 0 casuals voted. So who voted for the EA?
Well, there's another document you showed us. I think it was Sam that put it up on the screen, but you showed us the document. I think it was from Chandler McLeod to the CFMEU, saying that basically you will forego any appeal in future. And the union was basically going nod, nod, wink, wink to Chandler McLeod, go ahead and we'll shut up.
Exactly.
And Chandler McLeod would not go ahead. And I've seen that in black and white. Chandler McLeod would not go ahead without making that a condition, and the CFMEU agreed to that.
Exactly.
Reprehensible.
Yeah. Now, the whole time, what we've been talking about, just quickly, is always CMG and their ABN number. Yet
Chandler McLeod Group.
Yep, ABN ending in 052. Miraculously, my lawyers tried to say I was employed by a totally different company. So therefore, we couldn't go ahead with the class action.
So you were employed and paid by Chandler McLeod Group, but then they tried to give you, tried to change your employer in the records to Ready Workforce or something?
They didn't try to change the records. They just tried to say that we're employed by Ready Workforce, the company that never had the contract at the mine, never paid us weekly ever, didn't pay Coal LSL levy donations, didn't pay the compulsory employer super contributions. What else they didn't pay anything. They never paid us. They never paid anyone.
And that's important. That narrative that Reddy was our employer links back to one of the reasons, links back to the value of government contracts held by Ready Workforce is 0. You've got to go back to 2007 before you will find a Commonwealth government contract held by Ready Workforce. So the value of Chandler McLeod's current and ongoing Commonwealth government contracts for all departments is $629 million. I checked this morning at about 10:30.
That's per year? That's per year?
No, that's current and ongoing, as in it may be over 3-4 years. So,
but weren't the figures that Chandler McLeod Group had got $2.4 billion over 4 years previously?
That was combining a number of entities. Yeah.
Okay.
But currently, all time, Chandler McLeod Cloud has held $1.693 billion worth of Commonwealth government contracts. So that's from, again, about 2007 to the current day. Current day is worth $629 million, and that's approximately 2,000 individual contracts with the Commonwealth. But the other problem too, Simon and I face with this, with our ATO records, is that People Bank, which is another wholly owned company by Recruit Holdings, who own Chandler McLeod. Simon will correct me if I go off the mark here.
Recruit Holdings, let me just say, Recruit Holdings is the world's largest labour hire firm, and it's a Japanese firm, and it owns Chandler McLeod. Is that correct?
That's correct. And it also owns People Bank.
Yeah, it's not the largest. Let's just go back a bit here. Persol, who I think they are the largest, along with Hayes, Chandler McLeod / Recruit Holdings is third. They're massive. Now, this is where we can get into the government contracts and everything.
That's right.
Persol bought Programmed and Skilled, which was previously known as and Tessa Mining, New South Wales. Right? The union sold the labour hire company they set up for zero for around $68 million. Then all of a sudden they have a free flow of enterprise agreements employing everybody illegally as casuals, even though they're not casuals.
That's right. That leads us up. That was before the Fair Work Act.
While bad-mouthing casuals. While bad-mouthing casuals at the same time. They enabled the casuals. We've only got about 9 minutes left, and I want, before we finish off on that, I want to get a couple of points across, and then you can rip on the contracts because this is important. Now, Simon and Sam in Williamtown, when we met with you guys, we formed a little pact. We formed and agreed to 3 aims. The first aim that we agreed on was that we would get Simon his lawful and moral entitlements. Lawful and moral entitlements. You've had some of them rectified, but not all of them. You've got a long way to go. We're still going, and we will continue until we get them. The second thing is we wanted to stop all these practices across the coal mining sector in this country. That's the second one, and we will continue until we get that. The third one was we want justice for you and other coal miners as to what's happening in this case. We're not even close to getting justice, but we will continue until we get it. The other thing I want to point out is that, Simon, you wrote to Joel Fitzgibbon, the previous member for the Hunter, looking after your area in federal parliament, 6 times, not one response. I wrote to Joel twice, no response. I've written to Dan Repicoli, the current member, not one response. I personally delivered it to his office in Parliament, walked across from the Senate and delivered it, no response. What's worse is that when I publicly called out what was happening in the Hunter, Joel Fitzgibbon had the hide to turn around and say, well, we're so pleased that Malcolm Roberts has realised that casual labour rorts is going on. Realised I announced it. And then secondly said, but as for all this other stuff that the CFMEU, the coal long service leave, that's all rubbish. Now we found out that because of what we've been doing, Simon, the 3 of us, along with Stuart Bonds, coal long service leave was audited, had a review done at our instigation. And that found serious governance problems. It vindicated what we said. All the other things, everyone has run away from. So I just wanted to make that point. You've had, the union has been, the Hunter Valley CFMEU has been complicit in this, up to its eyeballs. There is corruption in the Hunter Valley in terms of, that's the only way it can continue, and it is continuing. Now let's take it into the federal sphere with Chandler McLeod and the ATO, please, Simon. Away you go, both of you.
Okay, so what we've got here is the owners of these labour hire companies. The 2 of them are the largest, 2 of the largest companies in the world, but especially in Japan. The other one, Hayes, is it's British owned, I think. Now, we've sent you through this report. They have massive amounts in the billions of dollars in federal government contracts. Now, what I've come up with, I'd always done my tax returns on time, and I'd never, ever gotten a tax debt. I was the lead claimant in the class action. I file, the matter in the federal court. I do my tax returns. All of a sudden, I get a message to say that I've been audited. Now, it just so happens to be that the years that I was audited was when I was employed by these labour hire companies. I then find out that I've got a tax debt. Now, I was confused. How can I not be paid the legal minimum requirement of the Black Coal Award and have a tax debt after I'd already been given my tax return? I put it through in those years, my tax return. I got my tax returns done. Then in 2016, I find out I'm being audited. Now, Chandler McLeod and their subsidiaries, whether it be RGF Staffing, Orion, People Bank, have a lot of people within the ATO. So does Persol, which owned Programmed. Now, I don't know how I ended up with a tax debt. So I've now contacted ATO Internal Intelligence, and they've been looking right through this. And what we've now discovered is the Piawi that they originally done.
What's a Piawi?
Which was done,
What's a Piawi?
That's the pre-injury average weekly earnings, which can't apply to coal miners, mind you. That Piawi is totally false because it's not what Chandler McLeod, ABN 052, paid me. Now, that's for 12 months prior to my injury. What they've added in is a previous employer, which was Tessa, from that year. Right? So what they're doing, they're conflating the yearly amounts that someone's paid and adding in another ABN and company that's paid you. So it looks like the last ABN has paid you that amount, which is totally untrue. Now, I was never, ever paid $92,000. Yeah, mate, yeah.
Yeah, just to say that I to have this piggybacking of ABNs. I worked for Chandler McLeod in 2014. It's clear as mustard, ends in 052. Then only recently I discovered that in 2016 that ABN appears in conjunction with the ABN of another labour hire firm, where it reports that a different company paid me, and that's part of the Tessa group. A different company paid me than it's actually. I have my PAYG summary. I give it to my accountant, and it's for Tessa group, and yet it gets filed when I visit it yesterday, on my ATO records. It's actually filed there under Tessa Mining, and it's ABN. So someone has gone in and changed them after the fact, and Simon mentioned that the ABN of another company appears in conjunction with it. Again, they're conflating the income somehow. We're just touching on what's wrong with our ATO records in that brief summary. Yeah, back to you, Simon.
Well, where we can go to where the Fair Work Ombudsman's involved in this now. The Fair Work Ombudsman has government contracts with People Bank, right, which own Chandler McLeod. Now, we've gone to the Fair Work Ombudsman. I've got an interview pending at the moment. And Malcolm, you've asked the questions of Sandra Parker, which confirmed everything that we've spoken about here today. Can't be removed anyway. This investigation, they came back and said, well, no, the Black Coal Award didn't apply because you didn't work for Chandler McLeod, you worked for Ready Workforce. And this 2007 zombie agreement applied from 2007 in 2014, which no one knew about. Now, mind you, that zombie agreement was done by the CFMEU. In the court matters and Stanton matters previously, it's never mentioned. But what they've done was, I asked this Robert Evans, the investigator for the Fair Work Ombudsman, how he come to that decision when every document, my PAYG summary, pay slips, everything showed it was ABN 052, Chandler McLeod. So he comes back and said, well, I've got your PAYG summary here, says it was 037, Ready Workforce that paid you. I said, oh, really? Can you send it to me? So he did. ATO has no record of that PAYG summary. My accountant at the time never had any record of that. The ATO, as I said, have no record of it. It's a fraudulent PAYG summary.
So they're trying to hide the fact that you were employed by Chandler McLeod Group.
Yep. And the
Why
reason
would you do
being,
that?
once, I'll tell you, we're employed under the Black Coal Award, so everybody is owed money. The difference between $66,000 and $144,000 a year. No, you're a full-time employee. You can never go back to being a casual. It shows the true value of the Black Coal Award. All of these enterprise agreements are no better, in fact, far worse than the Black Coal Award, and all negotiated and endorsed by the CFMEU and approved by the Fair Work Commission.
So, Sam, I think it was you who mentioned to me this morning the figure. What's the figure that you think is owed to miners across New South Wales?
For that one site, for an estimate of 500 people, you're looking at a band of $140 to $150 million. So
that's a bit of an incentive to shut things down and
correct and protect. See, once you're found to be undertaking wage theft, you'd think it would be questionable whether you're a fit entity to hold a Commonwealth government contract. And we've just been talking about their value. Yeah.
So, that's even bigger.
How do you have all the government contracts with the ATO, Department of Defence, Veteran Affairs, literally every single government organisation, they have these contracts. Now, not only Chandler McLeod, you've got Persol programmed and Hayes as well.
Wow. So let me just cut to the chase, and then I'll let you guys have the last say. The aim of this, when we first talked about this, Simon, in Canberra, and you came down, and then in the Hunter Valley, I said to you quite clearly, the aim of this to me looked like it was nothing more than a way to reduce pay rates. That was it, full stop. It's done more than that. It's removed basic safety protections of miners. It's completely removed the union in the Hunter Valley CFMEU at least, as being a protection for workers. They have been part of the people who have been bastardising workers. The union, the inept or weak regulatory agencies in New South Wales and in the federal government, ruthless labour hire firms. It could not happen if just one of those three stood up. But it's happened.
Exactly. None of this happens. They pick it up at the enterprise agreement approval process. If they simply check the documents and read it, which they clearly haven't, because blind Freddie could see where they've breached the laws in these applications. And they're stat decks, mind you. They are signed stat decks. So lying in a stat deck is a criminal offence.
Right, thank you. But this is big, much bigger than just miners in the Hunter Valley. This goes to serious government contracts. But let me just say something else for people to learn more. Sam, HVMA in the Facebook, HVMA site on the Facebook. We've only got a minute left.
Yes, it's Hunter Valley Miners Advocacy Facebook page. Yeah. It has covers a lot of the...
You've also suggested people who want to can go to AusTender, AUSTENDER.com.au if they want to understand more. The solutions, we always mention...
AusTender, yes. Yep.
Okay, we always mention solutions. This battle that we're in is continuing. We've been going 3.5, heading for 4 years now. We will continue until it's fixed. I hope Tony Burke is hearing that. We will continue until it's fixed. The solutions to this are truth and industrial relations reform, because basically what we've got is a monster of an industrial relations law that is far too complex and that therefore people cannot understand what they're entitled to, and therefore they've tried to hoodwink. What I'm going to say is a very, very heartfelt thank you to Simon and to Sam and to Stuart Bonds, because, mate, you guys have gone way beyond what any citizen should have to endure. And you have really nailed the far bigger picture. Quickly, we've got 20 seconds, Simon, and then we've got to say goodbye. Thank you so much for what you guys are doing.
No, thank you for your support and getting everything out there at estimates. We need to keep fighting because it's this simple. None of this can happen. If you apply all the laws that were currently in place, it's quite simple. If they check documents, none of this happens. This is the federal government's responsibility, and they've been doing it in conjunction with the CFMEU.
We will continue.